Welcome, I'm Kurt Kaplan with Kresge Legal and Accounting, and welcome to this Friday probate report for August 21st, 2020 for Clark County Probate Court. And today in probate court, I observed two attorneys arguing over a court order that was issued to the trustee to distribute $60,000 to the beneficiary. The trustee's attorney argued that the distribution is a taxable event to the trust, and therefore before any distributions are paid to the beneficiary, that applicable income taxes be withheld from the distribution before giving it to the beneficiary. The beneficiary on the other side argued that the court order specifically said that $60,000 should be distributed to the beneficiary. So let's talk about what's going on in the background, what was not shown and is not apparent to the public in this situation. First off, the trustee should not have denied distributing the money according to the previous court order. The court order is a court order, and there was no contingency and no argument about the $60,000 or the distribution from the $60,000. So the trustee should have distributed that money. And by the way, the court order ruled today during the probate court to distribute the $60,000. Here's why the trustee should not have resisted in making the distribution, is because all trusts are pass-through taxpayers, which means any taxable income that is at the trust level can be distributed to the beneficiary, and the beneficiary can pay the taxes at his or her level. So there's a major defect that's going on that ran through this whole situation. Is what should have happened at the very beginning was when the court order was issued to make the distribution of $60,000 to the beneficiary. That tax issue should have been negotiated during that time and gotten the court to order that yes, a $60,000 distribution should have occurred, but there should be a federal withholding amount and paid to the IRS because it's a taxable transaction. That's what should have happened, and that is the fault of the beneficiary's attorney for not arguing that, and also the trustee's attorney for not arguing that. And let me tell you something, this is the major issue going on right here. None of these attorneys that represented the beneficiary and the trustee have tax education. They do not have tax application. These two trustees arguing for these clients right here were trying to make a legal solution that fit around a taxable situation. The taxable situation could be very well simplified if they would have come to me. I would have counseled that trustee to make the distribution and then to advise the beneficiary at year end, oh, by the way, that's a taxable event to you. You're gonna have to pay taxes because we're reporting that to the IRS. The beneficiary would have had nothing to say then, because the court order that was in argument in court today is silent about the tax issues, and the court would not have been involved with that. So if you have any questions regarding distributions, taxability, and events that are happening in probate and trust administration, you sure need to make sure you get an attorney that not only understands the law, but also understands the accounting and tax implications involved with this. Had this not happened today, these clients right here would have probably saved $15,000 in attorney's fees arguing over this situation that was unnecessary by both of these. I'm Kurt Kaplan. Welcome to my Friday probate report. I'm with Kresge Legal and Accounting.